This is the Oki Doke, Season 1, Episode 7.
We are stepping into what can really only be described as a descent.
Yeah, that is exactly the right word for it, the descent. Because today, we are going really deep into the absolute darkness of this chapter.
Right.
We are looking at this incredibly profound, almost terrifying structural disconnect.
It really is.
Because we are going to explore what actually happens to a human life, human family, when a courtroom says one thing and the entire world hears something entirely different.
Right. It is the ultimate collection of realities because you have the quiet, methodical, often agonizingly slow reality of a legal proceeding.
Exactly.
This is the reality happening behind closed doors, logged on paper, and buried in court transcripts that, let's be honest, almost nobody reads.
Almost nobody gets.
And then you have the deafening roar of global public perception. And what you are about to see today is how wide the chasm between those two realities can actually get.
It's massive.
It's a gap so massive it practically swallows a man whole.
It does. And to understand that gap, we really have to start with what was actually happening in the legal reality. So as we covered, if you cast your mind back to that pivotal hearing on September 23rd, 2019.
Right, the preliminary hearing.
Exactly.
Yeah.
We saw investigator Robin Letourneau on the stand, and she confirmed, under direct questioning from the defense, that the entire extortion attempt against Kevin Hart was built on a single public Instagram comment.
Just one comment.
One comment left by a complete stranger in a public forum 26 minutes after Hart had already posted his own public apology.
And that is the foundation of the sworn record right there.
Right.
There was no extortion in any of the emails. It was purely a business deal. The prosecution's own lead investigator confirmed it remained a business deal right up until that public Instagram comment appeared completely out of nowhere.
So if you were sitting in that courtroom on that day in September, the original extortion theory, the massive sensational narrative that had basically dominated global headlines for a year and a half, it was fundamentally crumbling right in front of your eyes.
Oh, it was in critical condition. But here's the thing. The case didn't just end there.
Right. The machine keeps going.
Exactly. The legal machine kept grinding forward. And to understand what J.T. Jackson was actually facing, when millions of people finally heard his name on a massive global scale, we cannot just look at that September hearing.
We have to rewind a bit.
We do. We have to rewind the timeline slightly. We need to go inside the prosecution's office months before that explosive testimony just to see how the foundation of this case was being quietly dismantled and rebuilt behind the scenes.
Right, because timelines are totally colliding here. And to make sense of the collision, we have to look at the spring. Specifically, May 3rd, 2019.
May 3rd.
So let's step away from the September courtroom and look at the structural integrity of this case when it first started showing visible, undeniable cracks to the people actually prosecuting it.
Because on May 3rd, 2019, a new prosecutor takes over the case. His name is Michael Fern.
And Fern steps in, and his very first documented action, his immediate move upon taking the reins of this massive high-profile case, is to drop count 2.
Attempted extortion.
Right, attempted extortion. Remember, there were 2 original charges filed against J.T. Jackson back on May 2nd, 2018. Count 2 was attempted extortion. And on May 3rd, 2019, Michael Fern just drops it.
With absolutely no stated reason in the public record.
Oh, nothing.
No press release, no grand explanation to the court. It is simply wiped from the board, just gone.
Okay, let's unpack this for a second because, you don't just do that casually. Think of this like a massive building project.
Okay.
The original architecture for this prosecution was built around this idea of a brazen extortion attempt. Michael Fern comes in as the new head architect, looks at the blueprint, and his very first move is to quietly remove a massive load-bearing pillar without saying why.
That's a great way to put it.
He just yanks out count 2. Why is count 2 just gone immediately upon his arrival?
Yeah.
I mean, you don't drop a major felony charge against a high-profile defendant unless you've realized you absolutely cannot prove it.
Right, and what's fascinating here is what that quiet removal leaves behind. Because in law, a vacuum is never just empty space. It shifts the weight of everything else in the case.
Oh, totally.
By dropping count 2, Fern leaves only count 1 standing from the original complaint. Count 1 is extortion by threatening letter.
Right. Extortion by threatening letter. And the dates attached to that specific charge are, they're critical to understanding why this whole thing is about to implode.
Exactly. Because when a prosecutor files a charge, they have to bind it to a specific timeline. You can't just say a crime happened, generally.
Right.
Count 1 specifically covered the period from August 25th to August 30th, 2017. Now, connect the dots for a moment. That date range, August 25th through August 30th, is the exact same period that investigator Letourneau would later admit in open court had absolutely zero extortion in the emails.
Wait, pause. So the prosecution drops attempted extortion completely.
Yes.
And they're left holding extortion by threatening letter for a 5-day window where their own investigator knows, and will eventually testify under oath, that absolutely no extortionary threats existed in the communications.
None.
They have literally hollowed out their own case. Like, how does a prosecutor ethically or legally proceed when the dates of the alleged crime correspond perfectly with communications that contain no crime?
They're completely cornered at this point. The original extortion case is effectively a shell.
Just a shell, yeah.
The evidence does not match the charges, and the timeline does not support the narrative. And when you are a prosecutor holding a hollowed-out, high-profile case that the entire media apparatus has been covering for over a year, you cannot just walk away without a massive public failure.
You look terrible.
Exactly. You need a new path forward. You basically need to rewrite the reality of the case.
Which brings us to the summer of 2019. If you're listening to this and wondering how the legal system handles a case that is falling apart, well, the answer here is that the prosecution executes a massive, sweeping pivot.
A huge pivot.
They don't drop the case. They metamorphose it.
We are looking at August 8th, 2019. This is 3 weeks before that explosive September hearing where the extortion theory finally dies on the stand.
Right.
Letourneau, acting as the declarant who swears to the facts, and Michael Fern, acting as the deputy district attorney, both sign a brand new document. It is called the Second Amended Felony Complaint.
Okay, let's explain what an amended complaint actually is, because it sounds like procedural jargon, but it's incredibly powerful.
It really is.
Going back to the building analogy, this is the architect desperately changing the foundation while the building is already occupied. The original complaint is the foundational document that tells the defendant, here is what we accuse you of doing, and here is what we are charging you with. An amended complaint means the prosecution is literally changing the rules of engagement mid-stride. They're altering the charges. And in this second amended felony complaint on August 8th, 2019, they are introducing 3 entirely new counts that had never been there before.
They're completely changing the architecture of the prosecution. And let's break down these new charges, because you really need to understand exactly what they're putting on the table in August 2019.
Yeah, let's do it.
Count 3 is unauthorized use of personal identifying information against Kevin Hart. Under California law, this is an identity theft charge.
Wait, identity theft. How do you get identity theft from a situation involving a recorded video in a Las Vegas hotel room? Like, what is the legal threshold for that in California?
Well, under the California Penal Code, identity theft isn't just, someone stealing your credit card to buy a television.
Yeah.
It broadly covers the unauthorized use of someone's personal identifying information, which can include their name, their likeness, or other identifiers, to obtain credit, goods, services, or medical information in the name of the other person without their consent.
Cool.
So the prosecution is attempting to argue that the very act of possessing and allegedly trying to monetize this recording constitutes the unauthorized use of Hart's personal identifying information.
Wow. So they are taking a statute designed to stop people from opening fake bank accounts and trying to stretch it to cover a celebrity scandal video.
That's the theory.
That is a massive legal reach. And that was count 3. What else did they add?
Count 4 is the exact same charge. Unauthorized use of personal identifying information, but this time against Mantia Sabag.
Okay.
That is the exact same identity theft legal theory applied to the woman who is with Hart in Las Vegas.
So that's 2 identity theft charges manufactured out of thin air in August 2019.
Yep.
And then we get to the big one, count 5.
Count 5 is attempted concealing, selling, and withholding of stolen property exceeding $950 in value.
Stolen property.
And the stolen property listed in this document. It is specifically defined as the surreptitiously recorded images and audio of Kevin Hart. The sex tape.
Now, before we go a single step further, we have to state something with absolute, uncompromising clarity here. We have to draw a massive line in the sand.
Absolutely.
When we talk about count 5, when we talk about these new device-based charges, the identity theft, the possession of stolen property, we are talking entirely about charges filed by a prosecutor. We are not talking about proven facts.
That is a crucial, vital distinction for everyone listening. You must look at the documented record of J.T. Jackson's response.
Yes.
From day one, J.T. Jackson has completely, unequivocally denied what the district attorney's office claimed was on his devices. He has stood by this position consistently, without wavering, through every single proceeding in this case.
Exactly. We are presenting the timeline to you, so you can understand the mechanics of the DA's strategy, but you are the one who gets to decide how to weigh this. But you have to know, categorically, that JT has denied these device claims from the absolute beginning.
And we also need to look at what happens to the remaining original charge in this new document.
Right, the extortion charge.
Count 1, the extortion by threatening letter. It is still there in the August 8th document, but its timeline has been radically, almost absurdly stretched.
How so?
The original complaint for Count 1 covered those 5 days in August 2017. The newly amended complaint stretches that window all the way to April 30th, 2018.
Stop right there. April 30th, 2018, that is the exact day J.T. Jackson was arrested.
It is.
How on earth does a prosecutor justify stretching the dates of a single extortion charge to span nearly 9 months, culminating on the exact day of an arrest?
It is a phenomenal expansion of the timeline. And when you analyze this timeline of the device-based charges being filed, it raises an incredibly important, glaring question about the genesis of the arrest itself.
Oh, the math here is crazy. If you're listening to this right now, I want you to really think about the math here, because the math does not add up at all. Let's look at the calendar.
Let's do it.
The DA's office took possession of J.T. Jackson's devices in January 2018 during the SWAT raid on his home.
Right.
They held those devices for 3 full months before they actually arrested him on April 30th, 2018.
And if we connect this to the bigger picture, you might logically assume, as anyone familiar with law enforcement would, that a 3-month gap between a raid and an arrest means they took the hard drives, they searched the devices, they found the alleged stolen property or the evidence of identity theft.
Naturally.
And then executed the arrest based on those concrete forensics. You would assume the arrest was the result of what they found on the computers.
But the documented sworn record tells a completely different story.
It tells the exact opposite story.
Like, are you telling me it is standard practice to raid a house, take a man's hard drives, sit on them for 90 days, and then make an arrest based on something else entirely? Because as Letourneau's own sworn testimony later confirmed, the arrest on April 30th, 2018 was not based on device forensics. Letourneau testified that she arrested J.T. Jackson based on the assumption that he was El Jefe, the moniker, on the Bitcoin email.
And let's remember her specific admission regarding that El Jefe email. She admitted under oath that she had no idea who actually sent it. Her entire basis for tying JT to El Jefe was an assumption built on the fact that he used a very common, publicly available email platform.
This is mind-blowing. So the arrest was an assumption.
Yes.
It was an assumption based on an email platform. It was not a forensic device hit. And the actual charges tied to the devices, count 3, count 4, count 5, the identity theft and the stolen property, they didn't even appear on a legal document until August 8th, 2019.
Over a year later.
That is more than a year after the arrest.
Let's contextualize how bizarre that is within the lifespan of this case. These new identity theft and stolen property charges had absolutely nothing to do with the original September 16th, 2017 extortion investigation.
No.
They were not mentioned in any of the original warrant affidavits. They were not the foundational premise of the searches that led to the raid. They simply materialized out of thin air on August 8th, 2019, right as the extortion case was falling apart.
Okay, so the prosecution has duct-taped this new legal Frankenstein together. The extortion foundation is crumbling, so they build a completely new house out of identity theft and stolen property charges over a year late.
Right.
Now, we jump forward into the fall of 2019. We need to see how a judge looks at this metamorphosis in an actual courtroom, because eventually a judge has to look at this paperwork and decide if it actually holds up to scrutiny.
And that brings us to November 12th, 2019. The preliminary hearing that began in September resumes. We are back in the same room. Investigator Letourneau is back on the witness stand.
Let's quickly define a preliminary hearing for anyone who isn't a lawyer. This isn't a trial.
No, not at all.
A preliminary hearing is basically the prosecution showing their homework to a judge. The judge looks at the evidence and decides if there's enough probable cause to actually make the defendant stand trial. It is a massive hurdle. And what happens during this specific hearing on November 12th is a massive, seismic legal shift.
It is huge. Count 1 extortion by threatening letter. The original charge that started all of this.
Yeah.
The charge whose dates had been magically stretched to cover the arrest, it is formally dismissed in open court.
Wow.
Michael Fern, the prosecutor, actually moves for the dismissal himself, and Judge Carrie Bensinger grants it.
Think about the absolute shock of that moment. Why does a prosecutor move to dismiss his own charge? Because he knows it's completely dead on arrival.
Exactly.
If you are following the architecture of this case, the foundation isn't just cracked anymore. It has been entirely removed. The extortion narrative that launched search warrants, the narrative that launched a SWAT raid on a wedding anniversary.
The narrative that ruined a career.
Yes, the narrative that caused an arrest and ruined a man's life. It is totally gone from the active charges.
The entire original premise of the prosecution is gone. Judge Carrie Bensinger dismisses the extortion. And that leads directly to the rulings on the newly manufactured charges.
Right.
2 weeks later, on December 13th, 2019, the ruling is issued on what actually survives this preliminary phase and what will proceed to trial.
Let's look at the scorecard from that December 13th ruling. The judge has to evaluate this new identity theft theory. Count 3. The identity theft charge against Kevin Hart is held to answer.
Right.
That means the judge found enough probable cause for that specific charge to survive and move toward a trial. It does not mean guilt. It just means it survives the motion.
But look at what happens to the others. Count 4, the identity theft charge involving Montia Sabag, is evaluated by the court. Judge Carrie Bensinger dismisses it.
Okay.
And then there is count 5, the massive stolen property charge regarding the tape itself. Judge Carrie Bensinger dismisses that one as well.
So the judge looks at this newly constructed last-minute case and throws out 2 of the 3 new pillars immediately.
Yeah.
But then Michael Fern executes a pivot. Almost immediately after the ruling, Fern refiles the dismissed Montia Sabag charge.
It is a complex procedural maneuver, but it sets the final stage.
Yeah.
If we synthesize all of this, look at the stark reality of the case as of mid-December 2019. A case that ignited in September 2017 as a high-profile, explosive extortion investigation is now purely and exclusively an identity theft case.
An identity theft case.
Yeah.
2 identity theft charges. And neither of those identity theft charges even existed in the case file until August 2019.
The extortion is gone. The attempted extortion is gone. The stolen property charge is gone. This is the quiet, highly technical, documented reality sitting in the court file in December 2019.
It's just wild.
It is a completely different case than the one that started.
And now we take that quiet courtroom reality, that highly specific set of surviving identity theft charges, and we are going to slam it into the loudest, most powerful megaphone on planet Earth.
December 27th, 2019.
5 weeks. Think about this timeline. Just 5 weeks after count 1, the extortion charge was formally dismissed in open court.
Right.
2 weeks after the preliminary ruling where the stolen property charge was thrown out. On December 27th, Netflix releases Kevin Hart's documentary. Don't flag this up.
6 episodes. A massive global release. It is Hart telling his story directly to the world. And the Las Vegas situation is a central defining part of that story. The alleged extortion attempt is a central part of that documentary.
If you are listening to this right now, you are probably screaming at your phone. Like, how can Netflix air a documentary about an extortion case when the extortion case was literally thrown out weeks prior?
It's a great question.
Did nobody at Netflix check the docket? Did they not have legal compliance? I want you to picture the sheer scale of this disconnect. Tens of millions of viewers tuning in.
Million.
People in their living rooms, on their commutes, watching on their phones all over the globe. And the narrative they are being fed, the story they're internalizing as absolute truth, is the exact narrative from January 2018. J.T. Jackson tried to extort his famous best friend.
It is a staggering asymmetry of information. Because while tens of millions of people are streaming that documentary, let's lay out exactly what they did not know. What the entire world was totally oblivious to.
Run the list. What were millions of people entirely blind to while they watched this show?
The world did not know that the extortion charges were completely gone.
Right.
They did not know that count 1 had been formally dismissed weeks prior. They did not know that the lead investigator had admitted in open court that there was no extortion in any emails and that the entire foundation was a public Instagram comment by a complete stranger.
Insane.
They did not know that the arrest was based on an assumption about an email platform, not device forensics. And they did not know that the only active charges were identity theft charges that hadn't even been filed until a year after the arrest.
They didn't know any of it. The documentary is broadcasting an alleged extortion, while the actual legal reality, the pending charges against the man they are naming on screen, has absolutely nothing to do with extortion anymore.
It is breathtaking.
In the digital age, we have to ask ourselves a really terrifying philosophical question. What happens when the court of public opinion is operating on a completely different timeline and an entirely different set of facts than the actual court of law?
It creates an alternate reality. The public record is updated in a courthouse that very few people are paying attention to. The transcripts are filed away in a drawer somewhere.
Yeah.
Meanwhile, the public consciousness is saturated by a streaming platform with infinite reach. The streaming platform becomes the truth, regardless of what Judge Carrie Bensinger just ruled.
And this disconnect isn't just an abstract legal anomaly. It's not just an interesting law school hypothetical about media and the justice system.
No, not at all.
It has a profound, devastating human cost on one specific family. We have to hold the darkness of this fully. We are transitioning from cynical legal maneuvers to a completely shattered human reality, because this is where the timeline exacts its toll.
Let's look at the professional void. By the time this documentary airs in December 2019, JT Jackson has been sitting at 0 professional credits since January 23, 2018, the exact day of the SWAT raid.
Nearly 2 years. 2 full years of the phone not ringing. Imagine being an actor, a creator, a professional who has spent a decade building a network, and suddenly your background checks are flagging you as a criminal defendant in a massive, salacious extortion case.
And when that documentary drops, whatever minute chance he had of quietly weathering the storm is completely obliterated.
It's gone.
Because to the world, to the tens of millions of people watching those 6 episodes, he is not a multifaceted human being. He is not the commercial king who worked his way up from the bottom.
He is not the Navy veteran who turned down a $60,000 contract because he believed in himself so much he wanted to bet on his own talent. He's not the man who slept in his car in Hollywood parking lots just to make his dream a reality. To the viewers on Netflix, he is stripped of all his humanity. He is just one thing, the extortionist, a label for a charge that didn't even exist in the courtroom anymore.
And the collateral damage extends so far beyond just JT. You have his wife carrying the permanent trauma and the permanent damage from what happened in their home on their wedding anniversary. That raid didn't just upend a career. It violated a sanctuary.
It really did.
The place they were supposed to feel safest was torn apart by armed officers over an extortion theory that the DA later dropped. And she is carrying that psychological weight every single day.
And then there is his father. His father in St. Louis. I want you to really think about this man. He is thousands of miles away watching this horror unfold in the media.
Just helpless.
Watching helplessly from a distance.
Here.
Can you imagine the absolute heartbreak of knowing your son is in the crosshairs of a massive global narrative, seeing millions of people call him a monster, and knowing you can't fix it, you can't protect him?
The dynamic there is incredibly painful. JT's father was calling JT's wife behind his back.
Oh, wow.
Because JT was trying so hard to protect his father, trying to shield him from the sheer terror, the financial ruin, and the emotional stress of what they were facing.
Of course.
And his father knew that. He knew his son was putting on a brave face, so he would call JT's wife just to get the truth, carrying this massive, unbearable weight on his own shoulders, feeling entirely powerless.
Tens of millions of people watched the screen on their phones and in their living rooms. They consumed the entertainment. They ate their popcorn. But the truth of what was in that courtroom,
nobody saw it.
The dismissed charges, the admitted lack of extortion in the emails, the identity theft pivot, the fact that JT had denied the device claims from day one, that reality reached absolutely nobody.
It was an echo chamber of an outdated, legally defunct narrative, and it swallowed this family whole.
And JT's father, he just kept watching from St. Louis. He kept making those quiet phone calls, waiting for the resolution, waiting for the truth of the courtroom to somehow catch up to the noise of the world.
And he waited a long time.
He waited until September 18th, 2023. That is the day he took his last breath, still knowing his son's career was in ruins, and the situation was still unresolved.
The permanence of that loss against the backdrop of this legal timeline, it is the true cost of the dissent. It is what happens when the narrative outpaces the truth and the legal system is too slow to protect the people caught in the gears.
So as we close this out, we have to look at this profound disconnect explicitly. I want you to remember this timeline. The extortion charges were gone before the documentary even aired.
They were gone.
What millions of people watched was a story about alleged extortion, while the actual pending charges sitting in the courthouse were identity theft counts. They were only added on August 8, 2019. The arrest itself was based on an El Jefe assumption, not device forensics. JT has completely denied the device claims from day one, and the documentary reached tens of millions of people who knew absolutely none of this.
Next time, November 12th, 2019, the investigator on the stand. What she confirmed that morning about the emails, about El Jefe, about the document she signed without reading? 6 admissions, all in the official transcript. Episode 8.
Before you go, I want you to really mull this over. In the digital age, does the truth of the courtroom even matter if a streaming service has already told the world a different story? How do you unring a bell that has been heard by tens of millions of people?
It's a haunting question.
New episodes weekly. Share it. Someone needs to hear this.